I'd like to focus my attention this morning on the second issue raised in the appellant's brief. That issue is that that of the prosecutor's misconduct in jury selection. What occurred in this case is during jury selection, the state used or relied on an analogy to the game of Wheel of Fortune. And I guess I should back up just a little bit. I think what's important that I should mention first is that before launching into this Wheel of Fortune demonstration, the state informed the jury that we can't define what reasonable doubt is for you. That's something that you won't get an instruction on. That's something that we can't tell you what it is. That's sort of off limits. But then the state says, well, goes ahead and explains using the game Wheel of Fortune what reasonable doubt is, what the standard is under which they need to review the evidence in this case. What I've argued is that this is it's misconduct in the sense that it's outside the wide latitude afforded to the prosecutor. You're not even discussing the evidence at this point. You're discussing the standards under which you're supposed to view the evidence. And what's happening is the state is using the game of Wheel of Fortune to somehow explain, knowing that Kansas law, pretty plain statements of law that we don't inform the jury, define reasonable doubt for the jury. We don't go in. It's best described by the words themselves. Knowing that, the state still goes into this demonstration of Wheel of Fortune. And apparently, although it's not transcribed very clearly maybe in the record, but it appears that they're actually holding up cards of some kind or something. The prosecutor says, "This is my Vanna White." I don't know, I guess Pat Sajak, but holds up a number of these cards and saying, here, if we get to this point now, you don't have any doubt left. And the case that I relied to in here is relied on is State v. Finley. And really, I think this situation is analogous to Finley, because all that's really happening here is the state saying, cut us some slack. We don't have to prove everything completely 100%. And this idea of, well, we can have a doubt, but it doesn't, as long as it's not reasonable, that's okay. What I've argued is it's the same thing in Finley that's occurring here with this Wheel of Fortune, and the state saying, I can't prove everything. It'd be great if I had a videotape, but I can't prove everything 100%. So the underlying message is cut us a little slack. And if you have a doubt, is it reasonable? Is it not? If it's as long as it's unreasonable, then it's okay to convict. And so it muddles everything to a degree that I think does affect the way the evidence is viewed in the case and does affect the outcome of the case. I've argued that there's ill will demonstrated here under the standard of whether is this going to prejudice the defendant's right to a fair trial. Does this prejudice the jury's review of the evidence, in this case to my client's detriment? And what I've argued is yes. I mean, the state's essentially standing there during jury selection, and this is the panel, the whole panel is hearing this, so the jurors that do end up on, and that's one thing that I don't think I pointed out in the brief, is the jurors that are hearing this Wheel of Fortune demonstration are sitting in on the case.
It's pretty common, I think probably in 99% of the jury trials, whether they be a misdemeanor or the most serious felonies, that the prosecutor and the defense counsel engage the jury in discussing reasonable doubt.
Absolutely.
And I think the prosecutor tends to emphasize, well, it's not beyond all doubt.
Right.
And then the defense attorney tends to maybe lean towards, well, it kind of is. But in that, what are you suggesting here that gets limited? What's the problem with this? And I understand you just said that it's diminishing the state's burden, but in trying to distinguish what is beyond all doubt and what is beyond a reasonable doubt, is that not permissible discussion?
I think I would argue that it is permissible within some context. What I've argued here is that what's happening is we're likening this to some sort of game. The game Wheel of Fortune.
Happens all the time. I used to offend me to a certain degree, but they do the sporting event analogy. Okay. They do this Wheel of Fortune analogy. It just happens all the time.
Right. Well,
And are you suggesting that any kind of use of an analogy is inappropriate?
no, I wouldn't go that far. I think what I'm arguing is that it's the same sort of quantifying. How much is enough, and to the extent that we get to that point where the state's going, well, cut us a little slack. And I understand what you're saying, that when you're selecting a jury, if you're the state, you want to make sure that the jurors understand that it's not beyond all doubt. And I understand that. There certainly is that sort of ebb and flow to this question. And that's a fair criticism.
But we do have some cases that say it's improper to quantify by percentage.
Right.
That 95% sure is you don't have a reasonable doubt.
Right, and that's what I think.
Isn't that what you're arguing here? If you're saying 5 letters out of 6 is in effect setting forth a percentage.
That's exactly what I'm saying. Is that just like Finley, where you're getting to a quantification of it, and Finley that was found to be misconduct. And I'm arguing in this case, I think it's important in this case because the facts, from a harmless standpoint. And I know that this second issue is very much related to the first issue, that the state says, well, we're not going to define this for you. We're not going to put on, and then that's what happens. And then later, defense counsel asks for, well, let's just have an instruction on it, what it means. Well, that's denied, and when it's denied, the trial court says, well, but it says the defense counsel, well, you brought up all this stuff about what reasonable doubt means. Well, that's not what happened, actually, and the prosecutor doesn't address that, doesn't say, well, actually, if you recall, Your Honor, when we got into this, we went with the Wheel of Fortune demonstration, and under the facts of this case, we have a very narrow time frame in which the death occurred. That's corresponding with my client's alibi defense. His entire defense is based on alibi and reasonable doubt. There's a number of facts. I realize the state has their witnesses that say that this was not accidental. The defense has a witness that says these injuries that occurred are consistent with an accident. As I pointed out in the brief, there's one particular fact concerning the condition of the vehicle in this case. The grain truck that was examined by the KVI, they found it to be in perfect working order. However, the one thing that sort of had stuck out to that in that analysis and the testing that was performed is that they said, the state's expert said that if you left the grain truck up, the bed up, and then you turned it off, you leave over time, it'll creep back down. It's pretty consistent with hydraulics. Well, this truck has been sitting in a shop for an undetermined amount of time. At least it's been a while, judging by the condition of the vehicle. And that thing, it's been turned off. There's 4x4 posts holding it up. It's got a load of calf pellets on it. On that, so that's putting extra weight on this truck. The one thing that wasn't ever tested is what happens if you leave this truck sitting somewhere without running for months. Then you kick the post out, or it falls. Does it creep down, or is it fast enough? And we're dealing with a subject here who's an 80-some-year-old man. It doesn't necessarily have to be a complete slam. If somebody is underneath this vehicle and it starts to come down at a rapid rate, not necessarily, there may be no opportunity to escape. So that's one fact out of those the testing that I think is incredibly important to this case. And I think under this situation where we're discussing the state's burden, diluting that to some degree, that's going to make a real difference in what comes down to a very factually close call. I think that's essentially what I have as far as the arguments I wanted to present to the court this morning, and I can yield the remainder of my time.
Do you have any further questions of counsel? Thank you, counsel.
May it please the court, Chris Ailslager, appearing on behalf of the state. And when analyzing the allegation of prosecutorial misconduct, I think there's two factors that bear on this analysis. One is, when was this analogy used? And second is, what was the prosecutor trying to do? First, when this was during voir dire. This was during jury selection. It was not during opening arguments. It wasn't during closing arguments. It was not at a time when the prosecutor was trying to persuade the jury to do anything. It was before the trial.
Oh, now, Counselor, you're saying litigator didn't try to persuade the jury during voir dire?
That goes into the second point here, which is what was the prosecutor trying to do? He was trying to select a jury. He was trying to weed out those jurors that equated beyond a reasonable doubt with beyond all doubt. And the trial attorneys will tell me ad nauseum that this is a problem with them in every trial, that they always run into a juror that equates beyond a reasonable doubt with beyond all doubt.
And educate the others that are there. Let's be honest, that's part of the process.
Certainly, but this wasn't the point of trial argument before, a closing argument right before deliberations where the prosecutor is trying to persuade the jury to the strength of his case because his case hasn't even been presented to them yet. So this is before any evidence has been presented. It's before any argument has been presented, and it's before the jury has been instructed. So it's before the trial. And the point that the prosecutor was getting at was not trying to convince the jury one way or the other, but was to select the jury, to find those that really couldn't, even though they say, yeah, we all understand what beyond a reasonable doubt is, you can't necessarily take everybody at their word. He was probing to find out, well, what do you really mean by beyond a reasonable doubt? Do you understand it's not beyond all doubt?
Speaking of taking someone at their word, appellate courts have said there should be no definition of reasonable doubt because the words define it as well as anything. The words speak for themselves.
Yes.
And if that's the case, then any analogy, other definition is contrary to that, isn't it? If the words say what they mean and you can't define it any better, then any attempt to define it or to analogize it is contrary to appellate holdings.
No, I disagree. First off, there's been other appellate holdings out there that said, well, no, some analogies are okay. So the appellate case law is not uniform, that it's always wrong to try to analogize what reasonable doubt means. It's wrong to try to define it. An illustration is different from a definition in that it's just relating it to some kind of an analogy that people can understand and a situational kind of usage of it, an application of it, but not a definition of it. Certainly, some courts have had problems with analogies that put a quantifiable amount into the reasonable doubt equation, that there is some percentage point, as you pointed out, some quantifiable amount, but that didn't occur here. He just brought on virtually everyone, I would say, has seen the game show Wheel of Fortune. So it was something that was common knowledge to all of the jurors. They all understand that at some point in looking at the word puzzle, each person gets to a point where they are beyond a reasonable doubt as to what it is. It's going to be different for each person. He didn't quantify it. He didn't say it was a set amount, but he just analogized it to something they could all understand so that he could find out those people who really thought that beyond a reasonable doubt is really beyond all doubt.
He didn't say it, but didn't he demonstrate it as a quantifiable amount? I mean, it wasn't the point that you add more letters and, and as you do that, as you get above 50%, as you get closer to 100%, oh, okay, now we're there.
I don't think he explicitly said.
No, I'm not suggesting he explicitly said it. I'm suggesting that by demonstration, he can make the same point that we are reaching close to 100%, but maybe not quite there, and that's enough.
Well, in any reasonable doubt is necessarily less than 100%, or doesn't have to be 100%. But I don't think he took the jury step by step to a point and stopped and said, now at this point you've reached reasonable doubt. And he left it open for their own determination. But what he was getting at was, look, this isn't beyond all doubt. It's not beyond 100% beyond all doubt. It's beyond a reasonable doubt.
If the prosecutor had said that reasonable doubt is okay within 1/14th of 100%. That would be improper, wouldn't it? To quantify it that way.
Most of the case law would say so. Practically, I would say.
So tell me the difference when he holds up a sign that says Wheel of Fortune, where there would be 14 letters, and one's missing, that doesn't communicate a quantification of reasonable doubt equals, in effect, 13/14ths of the universe.
Because
this is close to a quantification when you do it this way.
But he didn't present it as a quantification. I think that's
It's a sign with a missing letter and says, I don't have to give you this missing letter.
But he didn't suggest to the jury that this is the measure of reasonable doubt. This is just an illustration an illustration of what reasonable doubt means, of how you can understand reasonable doubt, that it's not beyond all doubt. But there could be, we all know Wheel of Fortune has words that are 26 letters long and has some that are 4 letters long, and they have different, sometimes multiple words. He didn't call their attention to any kind of quantifiable measure. He used an illustration of a common game show that they all know. They're all familiar with.
He held up a sign on which was printed, quote, Wheel of Fortune with a missing letter. That would communicate to me that if the prosecutor can get within that quantification of the universe of information, that's reasonable doubt.
Well, I would just say that he didn't call their attention to that. He didn't make that argument to them. He didn't say it was a one-letter difference. At some point, no illustration is. You're picking any illustration you've got. There's always, if you really parse it down, you can get down to some quantifiable amount and say that's what it is. But I just don't think that's actually intellectually honest. The truth is that the people watching the demonstration weren't adding up the letters and going, "Oh, I see. If there's 14 pieces of evidence that I want to see, and the state only has 13, that's reasonable doubt." I really think that is really stretching what's going through the juror's mind. I think they're looking and saying, "Hey, I've seen that game show before. I've watched it many, many times, and I've seen letters pop up, and somewhere in there I just think, oh, I know what it is."
And I've watched it, for instance, with my wife, and one of us will get the puzzle before the other one. So are you suggesting that reasonable doubt is a subjective concept that will arise at different times for different jurors?
No, I'm not going to say that. I would say that certainly each individual, when confronted with facts and evidence, is going to make their own determination about what is a reasonable doubt, and that's not. You just can't get away from that. But no, it's not a subjective test, and certainly the prosecutor was not saying that it was a subjective test. He was trying to illustrate reasonable doubt for the prospective jurors in a way that they could understand, so that he could ask them questions about it and determine which ones really were beyond all doubt. And that's really what he was getting at here. Now, he didn't bring this analogy up again in opening argument. He didn't bring it up again in closing argument. It was not presented any time during the trial. The jury was properly instructed on the meaning of reasonable doubt. So ultimately, I submit that it was not prosecutorial misconduct. Having said that, I will certainly move on to address the other factors of the standard of review in case the court disagrees with me and thinks that the prosecutor stepped over the line. I would submit that it was not a gross and flagrant violation. It was what the prosecutor was doing was honestly just trying to select a jury. There was no, it was not repeated. It's not emphasized at any point in time in the trial, and there's no. Like I said, the case law is mixed on what you can say analogy-wise when it comes to reasonable doubt. So it's not that he violated any clear, unequivocal case law. That would reflect ill will. There were no objections. The court did not admonish him to control his questioning in any way, and he ignored it. It's not one of those situations. And ultimately, it's harmless when you look at the evidence in the case. The defense was this was an accident, And I think the evidence was pretty clear this was no accident. I mean, the victim had 3 crushing impact blows to the back of his skull. It was clear that happened before he was placed under the truck, that somebody did place him under the truck, and the only person that was around was the defendant. And then you add in the circumstantial evidence of all the financial arguments and problems going on in this family, and I think it's pretty overwhelming. So in light of that, I don't think that there was any reversible error. And if there are no further questions, that concludes my argument. I would ask that you affirm the lower court.
Any further questions of counsel? I see none. Thank you, counsel. Reserve 3 minutes for rebuttal.
I just wanted to reemphasize what, it's one of those, we're playing Wheel of Fortune. This man's on trial for murdering his father. So there's just a fundamental problem with approaching the reasonable doubt standard under this game show approach. And I think what is made, the point that's made and that resonates with the jurors, and the prosecutor asked, at what point, I guess the question I'm asking you, there's always something you could do in an investigation, for instance, and the juror says, well, yeah, up to a point, but at some point there's nothing else you can do. So as I've argued under the Finley case, this is a quantification, and it is just a cut us some slack kind of argument that we might get to that 1 or 2 letters, but if there's a couple elements there that you're not sure about, well, we're close enough is good enough. And I want to reemphasize the fact that the evidence in this case was subject to several different interpretations. I mean, defense counsel put on an expert that said these injuries could have definitely been to the back of the head, which the state's theory were that these occurred prior to the victim being. What the state's theory was that my client struck the defendant on the head several times, then from somewhere around 4 o'clock to maybe 6 o'clock, then dragged the body under the scissors of this truck, hoisted it in the truck, and put the truck down. The defense expert said these are injuries that could be consistent, or in his opinion, were consistent with the cranium striking the frame of the truck 3 times rapidly. So this wasn't a case of complete overwhelming evidence. My client had just returned to the farm. It's a very narrow time frame, maybe 2 hours in which this was supposed to occur. So I think that it does have an effect on the outcome of the trial in this case, and to dismiss it as being completely a harmless error in this instance would be erroneous. Unless the court has some additional questions for me, we would ask for a new trial and a reversal.
Any more questions of counsel? Thank you, counsel.
Thank you, Your Honor.
Thank you both for your arguments this morning. The court will take this matter under advisement. That concludes this morning's docket. Court will recess until 9 o'clock tomorrow morning.